due to the late delivery of vacant possession. And also, there is also the effect and impact on the defects liability period and the late payment charges and etc. Now, with the COVID-19 Act having a direct impact on our businesses, I believe many of our fellow developer members, especially who are very eager to listen to the panel of experts we have with us. So let us now welcome the panelists for our session today. Firstly, we would like to welcome Dato Engineer Soam Choon, who is currently our President of the REHDA Malaysia.
Thank you for inviting me.
Okay, and next is Datuk Kuek, Ngee Meng, a senior partner of Halim Hong and Kuek, who is actually helping us most of the time in the amendments and legislations. And we are glad to have him to actually give us a first brief on the impact of COVID-19, especially on Part 11. The next speaker is Dato Jeffry Muhammad Ali. Dato Jeffry is the head of consumer finance and also community financial services, CFS, of Maybank, Malaysia. Welcome, Dato Jeffry.
Thank you, Dato.
And lastly, of course, I think Mr. Simon David, who need no introduction to most of you. And Dato and Mr. Simon David is the Director of Licensing Division of the National Housing Department of the Ministry of Housing and Local Government, KPKT. So welcome, Mr. Simon David. Thank you for joining us.
Thank you very much. Thank you very much, Dato.
And without much ado, we would like to invite Dato Kuek to give us a rundown on the impact of COVID-19 Act upon the Part 11 itself, especially our Housing Development Control and Licensing Act 1966. Over to you, Dato Kuek.
Thank you, Dato Moderator. My name is Kuek, and then I'm going to give a briefing about the briefing on this temporary measure for reducing the impact of COVID-19 Act. In short, I've just called it as a COVID-19 Act. In particular, I will touch upon this Part 11, where how this Act modify or amend the Housing Development Control and Licensing Act 1996. As a brief, the first part of this Act, COVID-19 Act, the publication date is 23rd October 2020, and it shall remain in operation for 2 years from 23rd October 2020. And what it means is, unless it's being extended, therefore at the expiry of 23rd October 2022, it's not inoperative. However, the first question that comes to our mind is the late payment charges, the delivery of vacant possession, all this will be taken place about 2 years, 3 years later. It may perhaps after the Act become operative. Then what happened to this Act? Can this Act still be relied upon by the developer or purchaser? Yep, I mentioned about this Section 30 and 32 Act. Section 30 and Section 32 of Interpretation Act 1948 and 1967, which basically said that the matters is not being affected by repeal or the Act being inoperative. In other words, the repeal of or in operation of any written law in whole or in part shall not affect the previous operation of the repeal law or anything done or suffered thereunder. Therefore, even if the Act will become inoperative after 2 years, those sections which happened from 18 March, which I'll come to that later this year, or will be the right will be accrued. And the Prime Minister has tried to extend this the operation of this Act, and the extension may be more than once. And the real impact of this Act is there's any inconsistency or there's any conflicting provisions between this Act, COVID-19 Act, and other laws such as this HDA, this COVID-19 Act preview. Now let's go to this Part 11 on this HDA. In what way that this COVID-19 Act, modify and amend the HTA. First, the section is only about few sections, 32 to 38. And the first section is when does this modification come to place? On the 18th March 2020. And unlike the other act, it's only extend until 31st December, which is about another 13 days ahead of us. It can't extend anymore. I mean the impact, the operation date of this amendment to the HTA, and only confined to the agreement of Schedule G, Schedule H, Schedule I, and Schedule J. They enter before 18 March. In other words, before 17 March 2020. Those agreements enter on or after 18 March is not applicable by this act. And now come to this, there are few parts being amended. In short, is the main part is 34, 35, and 36. Let's go to this 34. The purchaser will be interested on this 34. Late payment charges. From the period of 18 March until 31st of August, if purchaser is not able to pay any installment, does the purchaser liable to pay the late payment charges or not? 34 sub 1 stated that if the purchaser cannot pay the installment due to the measure prescribed under the Prevention and Control of Infectious Diseases Act 1988, for example, like this MCO, EMCO, etc., then the developer cannot impose any late payment charges. You will notice that Section 34 exclude or waive or exempt the purchaser from paying these late payment charges is subject upon the purchaser able to prove that they are not able to pay because of the order being prescribed under this Prevention and Control of Infectious Diseases Act. The next slide I will show on this for this period from 18 March until now, there are various of these movement control order that we have experienced. Is the MCO. We know about that. No one can travel. Foreigner cannot come to the country. Why is it so important about this that no one can travel? Because for payment of these late payment charges, even though the bank is an essential services provider, they can open on 18 March. However, there may be some act that the purchaser need to do to open the account, to transfer the money, to sign certain documents, to meet with the bank officer, to arrange for the loan, etc. Or the foreigner may need to come into Malaysia to complete certain documents as required under the term purchase agreement or as required by the bankers, the M Financial. They may not be able to do it due to the MCO. These are the good reasons for them to not being for them to be exempted from paying the late payment charges. There are some other conditions that where we are still experiencing, which is the CMCO for those who stay in Klang Valley. Yep, we are still experiencing that. IMCO is the time that where the economic activity resume back. Therefore, during IMCO, if purchaser is not able to pay, and during this IMCO period, then there's argument. I believe that purchaser got to the burden for purchaser to prove due to movement control, they are not able to pay as the only reason. Then the issue, the dispute may arise that the developer may say no, there's not a good reason, therefore you have to pay. However, for foreigner, until now, they still can't enter to Malaysia. Therefore, they are in a better positions to say, hey, no, I can't pay because of this MCO period. This late payment charges, if a purchaser may apply more than once. Therefore, can see from this section 34. On one part, purchaser has to prove that because of the measure put forward by the government, they cannot pay. If they can convince the developer, then they are exempted to 31st August 2020. If they want to extend further purchaser, then they can apply to the minister for exemption to pay these late payment charges until 31st December 2020. Section 34 is deal with purchaser in paying the late payment charge, in paying the installment, and deal with the issue of any late payment charges that involve. 35 involve this the obligation from the developer to deliver the compensations, and if there's any liability to pay on these liquidated damages, or LAD in short. This part, this section, you can see is different from the way it's being drafted, is different from section 34. Section 35, it straight away exclude the period from 18 March this year till 31st August this year. The total of 167 days being excluded automatically. No need developer to prove anything. Only when developer need to apply for further extension from 1st September this year until 31st December, developer then need to justify their reason before the minister. On the other hand, you can look at this last paragraph of this slide. If the purchaser is unable to enter into possession of occupation from date of service of notice to take vacant possessions from the developer during 18 March until 31st August or any extended period granted by the minister, then only that purchaser shall not be deemed to have taken such vacant possession. The word there, if the opening word of if the purchaser is unable, to me as a lawyer, purchasers still have to justify a reason. They are not down by this being infected by COVID-19 cases, or their movement is not being restricted by the measure imposed by the government. I move on this the explanation of section 35. The calculation of date of this period. The period is the first part of the period that I mentioned is 18 March until 31st August. Then second is the 1st September until this 31st December. In total, we are talking about 289 days. This is the relevant period they are talking about. And I will show you some scenario for ease to understand. The first scenario is the SPA date is 20th July 2018. Then the VP, let's say it's a Schedule G agreement. The VP ought to deliver within 24 months. The VP date supposed to deliver is on the 20th July 2020. But because of this act, Section 35 has modified the statutory Schedule G agreement. The date from 18 March to 20th July is 125 days. Therefore, this period is automatically, it's not being frozen, it's being taken away. It's as if that 2020, for the purpose of this act, there is no such date from 18 March until 31st of August. The next day after you wake up, you sleep on the 17th March, you wake up the next morning, is 1st September. Therefore, this 125 days is automatically being excluded. And the timeline which allowed for the developer to deliver vacant possession is as it being calculated, resumed to be calculated from 31st August for another 135 days, which is, from the slide you can see, is 2nd January 2021. Another scenario, similar example, SPA is on this 1st January 2019, supposed to deliver on the 1st January 2021, because the entire period of this 167 days, 18 March until 31st August being taken away. Therefore, the Therefore, the supposed VP date being extended for another 107 days. This assuming that the developer is not applying for any extension from the minister. Another scenario, scenario 3, if the agreement signed on or after 18 March, then the agreement won't be modified. Whatever stated in agreement, be it 24 months, 36 months, or applicable. No modifications. The next scenario, similarly, for purpose of calculating the LAD, the SPA date, for example, is 1st January 2018. The supposed VP delivery date, 1st January 2020. But the developer can only deliver much later, about 9 months, 10 months later, 1st October 2020. Therefore, without this act, the developer is liable to pay the LAD for, in total, the 78 days, which can you see from the slide, plus 167 days, plus 32 days. In total, the developer ought to be liable for 277. If we add all together, it will be 277 days LAD. But because of this act, we take up this 167 days from 18 March until 31st August. And total LAD, which developer is liable, is 78 days plus 32 days, which is 110 days. And then definitely there will be some issue. The first issue is whether application for exclusion period of 167 days between the period from 18 March till 31st August is required by the developer and purchaser. Our answer is this is automatic extension, or it's an automatic exclusions from any calculations. And whether the application for another extensions from 1st September until 31st December is required by the developer and purchaser from the minister, the answer is yes. Both need to apply for extension. We note that this the practice from KPKT, Mr. Simon will confirm later that there's some administrative practice. The developer is required, even for the first period from 18 March until 31st August, developer is required to apply from the minister. And minister, the letter which I haven't seen, the approval which I have seen, it actually stated that the period of 167 days will be added into the time for delivery of VP. And such extension will be calculated based on the date of the first SPA duly executed by the developer with the purchaser. And there are two parts which the letter from the KPKT will state. One is to exclude the calculations of LAD during this period. And second is to waive the obligation to pay any late payment charges by the purchaser. In fact, the letter from the KPKT immediately put this section 34, which deal with late payment charges, and section 35, which deal with LAD payment by the developer, all in one place. This is the administrative practice by KPKT. Then we turn to the issue number 2. We know that this period, 167 days, being excluded from the calculation of VP delivery date and LAD. Then in practice, the developer did obtain EOT, extension of time, from minister, either up to from originally 36 months to 42, 48, some even longer. Then when does this 167 days being calculated? From the expiry of 36 months, which is prescribed under Schedule H, or from the expiry of the extended of time being granted by minister. Last year, 2019, November, Federal Court handed out these unmerely cases. The power for the minister or national or the controller of the National Housing Department to extend the period to deliver VP beyond 36 months under this Regulation 11 sub 3 of the Housing Development Control and Licensing Regulation is invalid ultra virus. And because of this case, all the extension of times all are subject to dispute. Subsequently, there are three cases that apply, three high court cases that apply on the Meng principle. Even though their facts are different from Meng, they rely on the ratio, on the decision, main decision made by the federal court in Meng, that any exercise by the controller pursuant to Regulation 11 sub 3 to amend the statutory sum of agreement is valid. And this claim, Lee Sai Song, Alvin Leong, Wong Hanfa deal with this Medini land, Medini project. In all these three cases, the High Court judges held that the extension of time granted by the ministry, signed by the national controller pursuant to Regulation 11 sub 3, all invalid. Therefore, the simple answer, or the most certain answer at this stage is the 167 days shall commence from the expiry of 36 months or 24 months, which is the statutory term of this agreement. That's for sure. Then whether this 167 days can be calculated from the expiry of EOT granted by the ministry, that is subject to how your facts are being different from the Meng cases. Because the three cases being cited, being reproduced in this slide are all under appeal. Now we know that this the minister actually they use this section 2.2 sub 2 to grant extension of time. But how valid this is subject to be seen. Yep, I see my time set is almost up to 10 minutes. The last few slides that was shown is this defect liability period. Defect liability period for extension is automatic extension for the purchaser. Purchaser can apply for extension, but not the developer can apply for extension, not the JMB and not the MC. Scenario 5 and scenario 6 is to show some example how the period being excluded as defect liability period being one excluded, how is it being how is it being put it back after 31st August to this scenario 5 and scenario 6. The saving clause of this act is any legal proceeding commence or any judgment or award obtained. Award means any award obtained from tribunal to recover the late payment charges paid by the purchaser or any LAD paid by the developer during this period from 18 March to 23rd October 2020 shall not be affected by this act. And commencement of proceeding is a filing of any claims with the tribunal under Section 16L of the Housing Development Act. Though now we know that the tribunal, same as the court, postponed all the hearing. And the latest we heard is from their fixed hearing in December. And for those hearing that which is postponed due to CMCO, they are being scheduled in January. But however, if the claim was filed between 18 March and 23rd October 2020, all these claims are not being affected by those provisions which I mentioned to just now, 34, 35, and 36. And the another modification on the act is to extend the Limitation Act to file your claim under this Section 16N of the Housing Development Act. Section 16N of the Housing Development Act said that you can file with the Home Buyer Claims Tribunal within 12 months from the issuance of CCC or within 12 months from the expiry of the defect liability period, whichever is later. But this period is being extended from 4th May till 31st December 2021. Sorry, 2020. Yep. I think that because of my time, I should wait for, I have some other presentation, particularly on this. I hope that this COVID-19 Act can be amended in my next few slides. I just stop here and pass the mic back to the moderator. I shall take opportunity if there's any question asked. Thank you, Dr. Moderator.
Okay. Thank you, Datuk Kuek, for what you call for such a good deliberation on the various clauses, especially in the COVID-19 Act itself. And I think this has probably raised quite a lot of questions in the mind of the participants. Now, if any one of you have any questions which you would like to direct to any of the members of the panel, then please record it down in the Q&A section. And as the time permits, then we will go through one by one, and we will get the the panelists to answer as to the best of their ability. And the next speaker that we would like to invite, Datuk Soam, who, being the president of the REHDA Malaysia, would have a lot of feedback on issues that is actually faced by the implementation of the COVID-19 Act itself. And as a result, sometimes there is also talk about whether if it is not so complete, then we might have to go into amendment number 1, amendment number 2, amendment number 3. So maybe we would like to invite Datuk Soam to share his views together with us. Datuk Soam, over to you.
Thank you, Dr. Charlie. Today we specifically talk about Part 11 of the Act. And you know, this Act came into operation from the 23rd of October after it has been gazetted. But it has a retrospective effect, as highlighted by Dato Kuek just now. Part 11, affecting the Housing Development Act 1966. On that part, the operation of that part of the Act commenced from the 18th of March, the first day of MCO. But there's no end date in that Act. But the whole Act, this COVID-19 Act, which is Act 829, Law of Malaysia, on the temporary measure for reducing the impact of COVID-19, 2020, talk about the operation effect for the next 2 years. Okay, but the issue here is that there are certain part of the Act which is related to our current Act, has a deadline, has an end date. Example like Part 2. Inability to perform, and a lot of our construction contract now falls into this ambit. So my comment earlier on that this Act actually did not cover the whole supply chain, okay, in a wholesome manner. That means it's truncated, looking at a certain aspect of the Act. And I can understand that Part 11 is one of the more complicated Act, because there are a lot of clauses related to it that affects the sentiment of the buyers. And to me, the main example I want to give here is like maybe on clause 36 relating to defects liability period. Okay, so now the 5.5 months have been excluded from the completion date. Similarly, these 5.5 months have then been added on as an additional defects liability period to house buyer. But in our contract with the contractors, okay, there is no such provision. Okay, there's no such provision. So making, meaning that the developers are exposed to this additional 5.5 months of additional defects liability period that will actually affect all of us as developers. For house buyer, of course, they will get another 5.5 months extension. Similarly, question raised is that developers' money in the stakeholder sum will be stuck there longer, okay? Or can the developer actually withdraw their stakeholder sum, which I don't think so, because the defects liability period has not ended. So maybe it's a question later on can be answered by Tuan Simon on this aspect of it, so that everyone is clear. I mean, these are the questions that I've been receiving from fellow developers as well as house buyers. On a similar note, as you're aware that COVID-19 has not ended. Okay, I mean the last couple of weeks after the lifting of the interstate travel on the 6th of December, I think many people thought that the virus is no more there. I see people traveling all over the place. You know, they're going to all the malls and whatever there is, and all the holiday resort place. Of course, we want the economy to actually prosper and improve. But at the same time, we understand that there are now a lot of clusters at the construction site because of this mass testing required. And I think daily you can see there are cluster relating to construction site, meaning that once there is a cluster, there will be a stop work order. Okay, and rightfully put by Datuk Kuek just now, that the certain part of the act will actually end on the 31st of December. But the problem is that current COVID-19 situation is not improving. In fact, the numbers are going up. Construction site has now been slapped with stop work order, and meaning that contractor will delay the delivery period to developers. And similarly, developers may be impacted in their delivery period to the house buyer. So the delivery time frame will now be impacted. So will there be further excluded period from the period that is already mentioned in the current COVID Act? Because the current COVID Act says that without doing anything, the period from 18th of March to 31st of August of 167 days has been excluded from the calculation of the completion period. Similarly, if we cannot complete, we can then apply to the minister and justify for an extension up to 31st of December. But if the event now happened in January, okay, my site is closed, my site is not allowed to be open, then what next? These are questions being raised regularly by developers. And at the same time, house buyers also asking, hey, will the house that I bought, will I be further delayed or not? Now with the COVID situation like this. So I believe that until we have the vaccine and where movement are no more control, and we don't have to shut down site and control movement of people, then the effect will be not there. Otherwise, you know, if tomorrow we have again a travel restriction, a buyer from Penang cannot come to KL to make payment. Example is a cash purchaser, or example we have a cluster in the one of the financial institution, and their people cannot release the the payment from the stage payment. We are going to have issue. Buyers will be slammed with overdue interest and all this. So what's going to happen next? So these are relevant questions being raised that maybe later on, maybe Tuan Simon will shed some light for us on this matter. And as to what can be done better on this, I think Datuk had some comment just now. He said he got a few more slides later on to say if the COVID bill can be extended and we are allowed to make amendments, what are the things that we wish for in the amendment that can happen. So maybe Dato' Charlie, I just start the thing by just pricking the minds of the thoughts of the buyers and the what, and then maybe later on can start a discussion on this. Thank you very much.
Okay, thank you, Dato' Soam. Basically, participants, I think you might have a lot of questions pertaining to some of the dates and the calculation of dates and so on. It's good that you actually present it to the panel now, because I think we have quite a good selection of speakers, and especially when Tuan Simon is actually with us, it's time actually to pick his mind and see his opinion on some of the issues. All right. Now, without much further ado, I would like to invite Dato Jeffry to share with us some of his thoughts, and especially on the moratorium that has ended on September 2020. What else is Maybank doing to assist borrowers, particularly in terms of restructuring the payments?
Okay, Dato' Charlie, good afternoon, and thanks again for having me, right? And this is our REHDA webinar. Yeah, certainly, I guess there are so many of our people are out there being impacted by the pandemic, right? And rightly said, I think the auto moratorium from the government had ended on the September 2020. However, I think as far as on the perspective of Maybank, we continue to basically try to assist, all these our customers through several repayment assistance. We call it RA, repayment assistance, which basically to target and to tailor-made to meet their current financial needs. And this repayment package including like no deferment of their monthly installment of their mortgages, a reduction of the monthly repayment to a certain amount, as well as maybe extension of tenure. But if we look at the government budget 2021 and the announcement by Bank Negara on the 6th of November, whereby all banks now is required to have a targeted repayment assistance, we call it the TRA, the Terminal Assistance. These packages are basically for all the selected B40 and micro SMEs. So what we are saying here is we never stop in really trying to do our social obligation to support, in particular, the B40 and SME40, SME, micro SMEs, as well as the M40 categories of our customers. So what basically the eligibility is basically like, we can have a deferment of their monthly installment for a 3 months period, or they can have another option like to reduce the monthly installment by 50% for a period of 6 months. So I think Dato' Saleh, even though the repayment moratorium had been actually ended, but I think as far as the bank is concerned, we will give option to all these impacted customers. We give them a comprehensive plan to basically to tailor-made the need of these customers in this challenges time. But to add to that, Dato' Charlie, if I may just add, further to Dato' Kuek and Dato' Soam mentioned earlier, should there be a wish list of the, say, the revision of the Act? I would probably urge, in terms of the e-acceptance or e-signing of documents as far as banks are concerned. So I think Dato' Kuek mentioned about the mobility loss. You cannot go to the bank, you cannot go and secure your document because of the movement restriction. So what if, if there's basically a amendment of the Act whereby actually all banks are allowed to do e-signing, e-signature, e-acceptance, so everything through digitalized, then I guess we should be able to assist the buyer as well as the developers. So that a bit on the how should be the probably if you were to have a wish list in the on the COVID Act revision. Dato' Jaleh.
Okay, thank you so much,
Thanks.
Dr. Jeffrey.
Yep.
Okay, the next speaker will be our Tuan Simon David. And one of the most pertinent questions that's been asked is that since the implementation of the COVID-19 Act, there's definitely a lot of questions has been posed to KPKT, and also what do you call the issues that has been raised. Now, what is your advice that you have been given so far? So for the benefit of the participants in this webinar, maybe we invite Tuan Simon to share with us some of the issues and also your advice on this. Thank you.
Thank you very much, Dato. I would like to refer firstly to the briefing made by Dato' Kuek just now with regards to the administrative measures requiring the developer to actually submit an applications in the on the applications of provisions 35 of the Act 829 with regards to the interpretations of the VP period and the LED calculations of LED. Now, basically, up until now, we have received almost 700 plus of applications from all of the developer. Now, as what Dato mentioned just now, the Act itself doesn't explicitly mention that you're required to actually do a submissions for the applications of that provisions. But the reason that we require the developer to actually submit such applications to KPKT was due to the fact that there is a need for a black and white confirmations on the interpretations of that provisions. Now, we receive a lot of complaints, queries, not only from the purchasers, but also from developers on how do we actually calculate and what does it mean? What does the provisions actually mean? Now, the first principle is basically, we are not granting you an extension. Now, this is not an extension. The second para might referring to the extension. What the act meant is basically that period of time from 18 March all the way to 31st of August is being exempted. All right. So that period that are being exempted will be substituted after either after 31st of August or after the first VP period based on your SMP, whichever that come later. All right. So that's what it means. We are not granting you an extension just like before under 11.3 or subsection 2.2. Now, we also received some questions with regards to if there's any rise on abandoned project or whatnot. For the time being, we're unable to actually speculate on that. There might be delay in delivery of project, but to say that abandoned project is a bit far, stretching it lah, right? Okay. Now, there is another issue concerning whether will it be viable for us to actually extend the period instead of until December 2020 all the way, I don't know, until March or whatnot. Now, as I mentioned earlier, this is a double-edged sword. If it's applied to you, it will also be applied to your purchaser, all right? Because the act itself doesn't differentiate either one, right? But what we may want to look into in the future, what if, for example, what Dato so mentioned just now, what if the delay occurred after December 2020, for example, if there's another PKBB announced in a certain period, at certain places in Malaysia, for example. Now, we may want to look into a start-stop mechanism, but it cannot be continuous all the way from 18th of March all the way into another further extension period, right? We may want to put it into AGC, the one that actually looking into all of these matters, and then but a good justification need to be relayed, and then so that they can actually consider that amendments or the provisions. All right. Basically, we already submit some kind of presentations to REHDA on the interpretations of the act itself and how do you actually calculate with regards to the LPC, the DLP, the LAD, and the VP. So if there's any further clarification required, you can also send an email to us, or just as what your purchaser are doing right now, submit a complaint or seek for clarification through the PMC, which is a website handled by Bahagian Undang-Undang JPM. All right, so I look forward to any further questions later. Right, thank you very much.
Thank you, Tuan Simon. Okay, I think we will go to the list of questions that was posted on the Q&A columns. The first question was, DLP extended 167 days from the 18th of March to the 31st of August. Will the 5% stakeholder sum that is held by the stakeholder lawyer also need to be extended? Maybe Datuk Kuek, I think you might be most appropriate to answer this.
Sure. Yeah, thank you. The stakeholder sums actually being stipulated. For example, let's take one example on this Schedule H, the third schedule, Schedule H purchase agreement, third schedule payment of purchase price, which is under item 5. This stakeholder payment, the release to be able to release to the developer, which is 8 months or 24 months from the date of VP. Therefore, if the VP actually deliver before 18 March There's no issue. No issue in the sense that it's not being amended by the COVID-19 Act. However, if the VP was delayed in the sense that it's being modified, as I give a few scenarios earlier, then you have to take from the actual VP date deliver as permitted under Section 35 of the Act. And then from there, you count. This is my short answer to this.
Okay, Datuk, I think the second question also is quite relevant to you. This is regarding the commercial SPA, which is not governed by the Housing Development Act. And this was also entered before the 18th of March 2020. Now, probably in the commercial SPA itself, they might have inserted a force majeure clause, right? So can the letter of POT from the consulting architect be used to extend the delivery of vacant possession for commercial SPA signed between the developer and the purchaser? Over to you, Datuk Kuek.
Thanks, Moderator. The first question is whether the force majeure actually cover this COVID-19. The word pandemic, epidemic actually stated there. If it's covered there, then the force majeure can apply. Both parties, both contractual parties, foreseen that anything about the spread of virus is part of the force majeure out of God that cause both parties cannot perform the contract. Then the contract can be extended based on the reason cited by the consulting architect. However, if the force majeure clause does not contain those relevant wording that I mentioned just now, then whether the contract being frustrated, I think that from the few series of webinars organized by REHDA, it's clear that it's not easy to prove frustration. Therefore, the short answer to that is look at your force majeure clause. Does it cover epidemic, pandemic, etc.? Thanks.
Dr. Charlie, maybe can I just
yeah, you can add. Yeah.
Because there's even you see in the PAM form of contract, it just say epidemic. Okay, it doesn't say the word pandemic. This is English word again. Of course, pandemic is a global event now, so it's a more serious than the thing. So if people want to try to split hair to say pandemic is not epidemic, then you cannot use a force majeure clause for a PAM form of contract. But currently, I believe that the take is that PAM has now recognized that the epidemic is a subset of a pandemic. So then the force majeure clause apply. But if in the force majeure clause, there's a force majeure clause in the contract, any contract for that matter, even this commercial contract brought up by this gentleman in question, doesn't have the word epidemic or pandemic there inside there. There can be a list of 100 things listed as force majeure. It's no use. You cannot use this clause to ask for additional time from your purchaser. That's my view. And I think you heard from, not only from Dr. Kuek, from the other two earlier lawyers, Dato Nitin and also Mr. Rajendra. So it's very clear that if it's not in your agreement and the word is not stated as epidemic or pandemic, then it cannot be used. The force majeure clause cannot be used.
Mm-hmm. Okay, thank you, Dato Soam. Do we have any of the panel who would like to add on this issue, on the force majeure clause? If not, then we go on to the next question. Now, our DLP ended in November 2020, but we are required to extend the DLP another 6 more months. And we have to extend the DLP to match. Can KPKT give an automatic extension on the defects liability period? Or sorry, the APDL. Can KPKT give an automatic extension on the APDL and exclude the requirement for us to provide deposit for the project since we already completed the project? In other words, during the extension of the DLP, whether the APDL needs to be extended or not. I think that is the gist of the question. Tuan Simon, you have any answers for this?
Thank you very much, Dato.
All
right. Okay. Thank you very much, Dato. Now, AP, which is abbreviation for advertisement permit, and BL, which is abbreviation for a developer license, is 2 different documents. Yeah. right? So when after your CCC, you're not required to actually renew AP. You're only required to renew your DL. Okay, right now, so long as the defect liability period is not concluded, you are required to actually ensure that your DL is active. Right now, with regards to the deposits, the issuance of the deposits are required under Section 6A, which is the controller to keep the deposits until the expiry of the defect liability period of the housing development. So meaning that you have to make sure that the deposits are as such and should not withdraw it until the project, the defect liability period, which is in this case is being extended, is concluded, right? But currently, we also, I think quite a number of the REHDA member is also aware that there is a 80-20 provisions of your deposits, whereas you can actually withdraw 80% of your deposits after you actually obtain CCC. And the 20% is being withheld until the DLP period has been concluded. So this 20% cannot be actually withdrawn until your DLP period, in these cases, which already be extended, is concluded, right?
Okay. Thank you, Tuan Simon. One more question for Datuk Soam. I think this is from our side itself. Even though COVID-19 Act does provide some relief, it's not sufficient to fully help ease the problem faced by developers, right? So unlike purchasers who appears to have greater protection and relief. So in fact, some of the relief provided under the Act may be detrimental to the developer for instance, the relief granted to the purchaser to delay making payment of the statutory installments, right, for the purchase of property. That one actually favors the purchaser itself. Now, this rescheduling will then heavily affect the cash flow of the developer, who has to maintain its workers, the leasing of machinery, and the payment to contractors and suppliers, among other ongoing construction projects. So what's your comment on this, Dato' Soam?
I think on those who are getting in financing, I don't think is a major issue because bank has started operation and bank has released most of the scheduler payment due under the schedule G, H, I, and J as highlighted earlier, because the clause 32 to 38 is only applicable to these four standard SPA being used under the Housing Act. And for cash purchaser, unless can be proven that they cannot travel to make their payment, because it has to be, like you say, PCID, is due to the prevention of infectious diseases under the Act 342, then they are not entitled to exclusion. So in this case, if really there's a enhanced MCO or CMCO where travel is not allowed, then you have to, not receive payment. The number of cash purchaser we have today, I don't think there are many currently. Of course, we will be disadvantaged as the developers will be disadvantaged in the sense that our payment for the stage that we have completed is delayed. You may be that unlucky that you have finished that stage and then fall right in the smack of MCO, and I mean, there's no recourse for us to it because that exclusion has now been given. No point for us to cry over spilled milk now. It's a matter of going forward. Maybe these are issues that has already arisen, and if there is any amendment allowed, maybe these are things that we can further look at. And one of the ways to mitigate further closure of your site and prevent your site progress from being delayed is to actually comply to SOP. Ensure that your site is not infected, and then you have a stop work order. I think that's a very pertinent question asked by many people. Is it, hey, why don't they follow SOP? Why their site get infected and all this? I mean, things do happen, but I think that's the best medicine we have now to prevent cluster from happening at our site and to prevent it from the site from being closed. I think even with the CMCO, unless it's a EMCO, enhanced MCO, if just the CMCO, I think the government has allowed all economic sector to continue, including the construction activities. So that's my answer for now.
Okay, thank you very much, Dato' Soam. Tuan Simon, I think this one quite a pertinent question. This is actually regarding the what you call the commencement of the 167 days. I think from what we have heard from Datuk Kuek just now also, when he was presenting, the 167 days commence from, let's say for example, the completion period is 48 months. And it actually commenced from the expiry of the 48 months. But from a lot of discussion, there is actually views that should commence it from the 36 months and do not take into consideration the extension that was given by the housing controller as a result of the Ang Meng Lee case. So this confusion, what is your advice on this, Tuan Simon?
All right, thank you, Dato. Firstly, I just like to extend further on what Dato' Soam was mentioning just now with regards to the implications of the LPCs and whatnot, because we have to take into consideration that we receive quite a number of complaints from the purchaser that also argue on why an exemptions on LED and VP are being granted to the developer sites. All right, so as I mentioned just now, this is the applications of this act is actually a double-edged sword, because the purchaser also argue that they are still servicing the loan and paying the rents during that period. All right, so we have to take that into consideration. Okay, now secondly, with regards to when and which number of months the calculations of these 160 days, 67 days should apply. Now, we have to take into consideration that the provisions of the Act saying that notwithstanding any agreement entered into between the purchaser and the developer, the period from 18 March until that should be excluded from the calculations of the VP and the LED. Now, the Act is explicit in such a way that it doesn't actually mention a period of the VP based on the SMP, the statutory SMPs. All right. Now, for you to actually apply the decisions of the federal court, now you actually have to challenge to overrule it. Right, meaning that so far as we are concerned, the extension of time that was granted to the developer still stand unless the court actually overrule it as such, right? Because as what Dato mentioned just now, there are two types of amendment of the SMPs that occurred right now. Number one is under 11.3. The second one is under exemptions under 2.2, right? So basically, the calculations with regards to the exemptions of 167 days will be based on the SMP that is signed between the developers and the purchasers, unless the court rule otherwise, that the calculation will be based on the 36 months, right?
Okay, thank you. One question for Datuk Jeffry. Many purchasers have expressed a lack of flexible payment packages. You know, in Singapore, the moment the COVID-19 impact happens, the bank came up with a lot of new repackaging of the loans, and some of them were actually allowed to pay interest only, and some of them were then allowed to reschedule some of their loan payments. So because of this lack of flexible, as well as also too strict criteria imposed on first-time home buyers, are there any plans for Maybank to assist these groups of people in financing their homes? Dato' Jeffry?
Dato' Charlie. Dato' Charlie. Of course, I think for Maybank, we fully support, or rather we continue to give full support to first-time home buyer, right? Especially if the house is for their own occupation. I think for this, I think we have our, we call it My First Home scheme financing, or SRP, scheme Rumah Pertamaku. We have that scheme basically to which we offer even margin of advance of 100 up to 105%. So we are not slowing down. Basically, we are not slowing down. We are doing our part also to assist a lot of these first-time home buyer. In the same time, we also have our unique product features whereby we just call it Maxi Home Easy Pay Less, Pay Later, meaning this is basically a scheme whereby it's zero monthly repayment. The house borrower, the home borrower only need to service the interest for the first 5 years. So we are coming out with a lot of flexibility. They only need to service the first 5 years. And then with this, basically, we are supporting that particular borrower, lower financial commitment monthly for the first 5 years. I guess because at this point of time, they are still renting a house, right? So they don't have to come up with much repayment obligation to the bank. Hence, they still have some cash in hand to support their life. So in short, what I'm saying is we continue to support the industry. We continue to support the Roma, scheme Roma Pertamaku, and we never slow down. I think in the environment currently that we are Dato Chia, whereby this is probably the lowest, if you care about financing rate, interest rate, we call it. The OPR is probably the lowest, right? At 1.75. Therefore, it's actually very cheap for our customers to really come forward to the bank and get their loan financing. So we'll continue to support this. We never slow down. Put it that way.
So in Dato Jeffry,
yep.
What happened is in order to encourage what they call the sales, and also for the easing of the entry points of a lot of purchasers. In the past, we have this developers interest-bearing scheme, DIBS. Do you foresee that there's a possibility that DIBS will be reintroduced back as a result of all these issues? Because many of them would then have difficulty in paying the down payments.
I think anything is possible, Dato. But this again pretty much up to the industry, how we want to react to the demand of the public, right? And if say the developer is comfortable to give or to bring back the IBS, whereas the bank also comfortable with it. So I guess there could be a possibility that it might come back again. But again, it's really up to basically, because DIBS is basically between the purchaser and the developer, right? So I give you the support. I assist you to service your profit rate with the bank while when the building is under BICC. So as I said, anything possible if we really want to probably make sure that the industry really pick up. Dato.
Okay, thank you, Dato Jeffry. Tuan Simon, another question for you. Following your answer, are we required to extend our developer's license? Because technically, our DLP has ended in November 2020. If so, can you make an automatic extension rather than we have to apply again? Because it would involve submitting documents and deposit again, which is beyond our defects liability period. So over to you, Tuan Simon.
We cannot actually automatically extend your DLP, as I mentioned just now, because it's there is different circumstances that apply to different projects and developers actually. As I mentioned just now, there is provisions with regards to the deposits, the amount of deposits and the balance, and also your obligations with regards to how many periods of DLPs that extended DLPs that are you subjected to. Now, if we were to actually extend it automatically, it will actually become a blanket approvals. It will be applied to all, which won't be fair to everyone which have a different circumstances altogether. Right?
Okay, thank you so much, Tuan Simon. Next question, I think we will refer to Dato Kuek. I think there's a question here. The COVID-19 bill have a suspended period of 167 days, right? But there is no mention on a contract between the developer and the contractor on the period which the contractor need to submit application to justify the number of days delay due to COVID. architect will evaluate the application, and if the EOT granted is less than 167 days, can the contractor bring this to arbitration or the court, as the developer has already obtained 167 days, but is never back-to-back and passed down to the contractors? You have any answer for this?
Yep. But the moderator, this is exactly like the president of REHDA has mentioned quite a number of times. This COVID-19 Act is a piecemeal rectification basis. It's not cater for the entire construction supply chain. This is a typical example. On one part, the purchaser is being exempted if they can manage to prove from paying the installment. On the other part, the construction contract is nothing to do with the modification on this HDA as per Section 32 to Section 38 of the Housing Developer Act. And hence, the short answer to that for the contractor or developer, or for the developer to rely on whatever this amendment, whatever modifications to the HDA before any applications, there's a different piece of what I'm trying to say is that doesn't jump at all. It doesn't oblige the arbitrator to be bound by any amendment to the Housing Development Act. This is my short answer to that. Dato Moderator, might I just come back to Mr. Simon's answer on this EOT extension under this regulation 11(3). Just a short comment on that. I definitely respect the KPKT decision on those extension of time under regulation 11(3) is valid and to challenge. However, this is not the right approach. It's not the right. In a way, it's not responsible. Pardon me if I say this word, because that this creates uncertainty in the industry. The many cases have been there for more than 1 year, and until now there's no active rectifications on the Housing Development Act to cater for striking down of regulation 11(3). This opened the floodgate that purchaser is suing developers that their EOT is invalid. And it also opened for the developers to seek an indemnity from the controller. But it's saying that because we rely, as a developer, rely on the controller decision, and that therefore we complete the entire project within 48 months. And now this reliance has no basis because the act to extend the extensions is being fought, and therefore the whole thing about this HDA is uncertainty. Therefore, we have this statutory Schedule H and G. If something is not certain, I wonder if Mr. Simon, since you are here today, we have this opportunity to convey our message. The ground message is quite clear. Hopefully, this the message to the minister, to the KSU, or to the AG chambers, that to rectify the uncertainty caused by unmany case can be done as soon as possible. Thank you.
Perhaps Tuan Simon would like to brief us. Is there any developments on the KPKT side regarding these issues on Meng? Yeah, thank you.
All right. Thank you, Dato. Now there is no provisions in the current act to actually supersedes or remedy on the approval that has been granted by the controller. But we are looking into right now amending the current act and its regulations to ensure that future applications with regards to pertaining to amendments of statutory documents is much more explicit and much more thorough in terms of how to go about it, and if there is to ensure that as what you mentioned just now, ambiguities doesn't occur. But as of it right now, the temporary measures that we are looking in right now. But as you mentioned just now, applications of Section 2.2 is open for interpretations, and currently there are no challenge by the purchaser, but we also quite interested to see how the stakeholders, especially not only the developers and the purchasers, in these cases, to actually took with regards to the applications of that provisions to actually amend the SMP.
Okay, thank you so much, Tuan Simon. Okay, Datuk Kuek, I think there is this what you call issue on commercial SPA and housing HSPA. As we all know that housing SPA, you can actually refer to Part 11, and that would actually answers to some of the what you call contractual issues that has arisen as a result of the delays. So can we say that the commercial SPA has to be governed by the Part 2 in that sense, that it refers to the Section 7 of the COVID-19 Act itself regarding the construction contracts, and you treat this as if like it's a construction contract? Datuk Kuek.
Yeah, Part 2 of the COVID-19 Act, particularly on Section 7, lists down a list of contracts, which I read. The one that come under this list is a construction work contract or construction consultancy contract, and any other contract relating to the supply of construction material, equipment, or workers in connection with a construction contract. Therefore, commercial sale and purchase agreement doesn't come under this provision, unfortunately, or the literal the reading. And I think that the Minister of Housing, KPKT, actually have a foresight. From newspaper, I understand that there will be this proposed commercial property act. Yep, it's governed on this commercial side. And, but at present, before that act being passed, till now, the commercial contract is being excluded under this COVID-19 Act. They have to argue based on the contract that they have signed.
Okay, thank you, Datuk Kuek. Tuan Simon, there is this question regarding the inability, as a result of the inability of contractors to perform efficiently, and due to the measures prescribed by the PCID Act, especially the COVID testing, the sanitization, the loss of foreign labor, and also the slow mobilization when they start to commence back the work again. So the cost of construction have actually increased many folds, and many developers actually may have to increase some aspect of their selling price of their products to cover for all these costs that has arisen. So would KPKT agrees to a review of the selling price frozen by the granting of the APDL stage, and then subsequently ask for a revision in that aspect? Thank you.
I will need some further clarification, Dato. What do you mean by freezings of the APDL just now?
Freezing means the developers can only sell those products according to the pricing that has actually been approved by KPKT at that stage of time. But due to all this increase in cost, there is a request whether they could actually revise some of the pricing. And if they can revise the pricing, can the KPKT give a blanket approval on this revision?
Okay, Dato, thank you very much on that. Now, we have to remember the first principles of granting the APDL is basically we don't actually control your selling price. Now, the selling price might be controlled either by the state's government for the rumah mampu milik, etc. If it's under PPAM or rumah wib project, right? We only control what you advertise, all right? The selling price is what is covered under your advertisements and your brochures. Now, that is the provisions that we actually control. Now, if there is actually changes with regards to the selling price, you have to submit applications of amendments of your selling price. because it also affect changes to your brochures actually, right? Because we don't want the future purchaser, for example, I found out from my neighbors, my future neighbors, that actually they purchase their unit for example, 1 million ringgit. Now after the COVID, etc., when I want to buy the unit cost me 1.2 million, right? And then when I check with KPKT, the price list and the KPKT still maintain as 1 million because there's no changes with regards to the brochures and etc. Right? So if the purchasers are to actually complain or to make inquiries to the KPKT, the only reference that we have is basically the price list that you actually provided when you actually apply for the FPDL. Okay, we don't actually say that no, you cannot actually amend your price after you obtain your FPDL and etc., because that is your business decision. But the administrative measures that we take right now is basically if you only obtain your FPDL less than a year, then we don't actually consider your request to actually amend the price list, because there will be implications on the purchaser side. But taking into considerations the COVID issues and everything, so long as you can actually justify, all right, the price increase, and then it is supported by the documentations and your QS and report and etc., because there's a format in applications of your amendments of your selling price, then the housing controller may consider it. Okay.
Yeah, thank you so much, Tuan Simon. Okay, one question that just came in is our project was handed over in October, and there have been defect rectification forms submitted by purchasers. The contractor's progress has been affected due to MCO or the supply of materials being held at overseas port. However, purchasers keep raising Section 30 of the SPA regarding the developers need to rectify within 30 days. So is there any advice on how we can address this matter with the purchaser? Maybe Dato Soam, you would like to answer this?
If your material is coming from overseas, there's nothing much you can do in trying to complete the work. Example, a spare part for your lift or escalator or whatever is something that you cannot, because it's due to the lockdown. Of course, there must be evidence to show that there is a lockdown in that country, the country can't produce it. So the onus of proof is probably on the developer side for you to prove that you cannot actually operate because of PCID. And I mentioned earlier that the shortfall of our act is that it doesn't cover issue about what happened overseas. Singapore Act is a bit different. It covers about COVID-19 in overseas territory as well, because they forgot that our border can be closed, material cannot come into Malaysia. So this is an area that I actually wanted to highlight to say that this is an area that is also causing problem in terms of defects being able to repair within 30 days. Of course, we can also understand that developer must not take advantage of the situation. It's because of their own doing, they can't repair, then they use the excuse that the material is coming from overseas. So if later on the buyer take you to court, the onus of proof is on the developer to prove that that material cannot be obtained on time from overseas. So I believe that the rational buyers will understand if you can show them proof that this material is really cannot be obtained at this current moment. And if after showing proof, the buyers still do not want to accept, I think this matter can be referred to the Minister of Housing. And we have this mediation process as well, mentioned in the clause 9, in the part 2, section 9 on mediation. And I think the PM's department under Ministry of Law has set up a PMC, Pusat Mediasi, where you can actually send it in. And if you are within a certain category, the quantum of fees is up to a certain amount. It's all there. It's all published in the website. And I think the public as well as developers can go into the website to look at this Pusat Mediasi. I think probably many of them is not aware that this pusat mediasi. There's a lot of information there, so please go in there.
Okay, thank you, Dato Soam. Okay, I think this question will be dedicated to Tuan Simon again. Okay, essentially the COVID-19 Act provides relief for agreements entered in from 18th of March to 31st of December, right? This is the relevant period. Now, if there is a need for an extension beyond 31st December 2020, on what grounds can the developer request to extend this relevant period beyond the 31st? And as we all know that if the minister fails to extend before the 31st December 2020, is he time barred? That means to say he has to act now in order to extend it. So what's your view on this, Tuan Simon?
All right. Now, the provisions under Section 11 only allow for the ministers to actually grant an extensions up until 31st of December 2020. Now, this will be a continuous period now. There is we have yet into looking into the needs to extend it further, because we have to take into consideration various factors that also will affect such decision by the ministers, because this is not only affect the developers but also the purchasers. All right. So for the time being, if we read the provisions of the Act 829 as it is, an extension can only be granted until 31st of December 2020. That's it.
Datuk Kuek, you have any views on this, the extension to 31st? You're okay with it?
Tuan Simon, whatever Tuan Simon says is correct according to this COVID-19 Act, unless this Act was being amended sometime in the next parliamentary sitting. Otherwise, there is no further extension beyond the 31st December. Datuk Moderator, wonder if I just say something about this pusat mediasi COVID-19 Act.
Please do.
Yep. The question that raised just now is on this defect liability period, where the victim possession delivered on the October and purchaser complaining that why so long, why take longer than 30 days. And then, of course, know that there's a 30 days for a developer to rectify. If can't rectify, then purchaser go and source their material, then they will rectify. But before they do that, they have to give a quotation to developers. Coming to short answer to the purchaser is, hopefully you can be, short answer to the developer who brought out these questions is, try to be patient. Ask the purchaser to be patient. Even though then they themselves want to seek alternative arrangement, they will face the same problem. To keep complaining doesn't solve the issue. This is a short answer to a developer. But back to this, whether the mediation center COVID-19 can take on this, has jurisdiction to hear anything under this Housing Development Act. Can you say that this is construction or construction-related renovations? Where I'm not so sure about that, because on this all defect liabilities claim, all is parked under this Home Buyer Claim Tribunal. And for those construction contract, lease, tenancy, etc., which come under the jurisdiction of the mediation center, they are efficient in the sense that they ought to decide the cases or mediate the cases within 14 days. And once mediated, both parties sign, and that constitutes a settlement agreement can enforce in court. However, of course, the entire process voluntarily. This is quite useful. The only thing there is, I think they must be quite busy. I tried to call them out to check how efficient they are for the past 2 days, but no one picked up the call. Anyway, all their applications online, as what Dato Soam said, a lot of information in the website. Do make use of these mediations, because at the end of the day, our society has suffered enough from this movement control. A lot of fatigue, a lot of anxiety. Let's mediate and obtain a win-win situation instead of everything go to court, everything complain. Thank you.
Yeah, okay, thank you. I would like to seek the opinion of all the members of the panel. I think this is an issue where it is very rampant during the MCO period, when the parties are not being able to mobilize themselves and to come to the officers, either in the solicitor's office or even in the developer's office, to sign the, what you call the SPAs and to be witnessed physically. So there is this question on the e-signatures or digital signature. So we all know that in Malaysia, we actually had two acts. One is called the Digital Signature Act, 1977. And the other one is the Electronic Commerce Act, 2006, which has been enacted in Malaysia for some time already. Yet e-signing is not widely practiced, especially for official documents such as SPA signing. So, but in view of the unprecedented events that we are all experiencing, would KPKT consider accepting e-signing and include it as one of the provisions in the HDA, now that the HDA is currently being amended? Tuan Simon, your view first. E-signing.
As it stands right now, the provisions of the regulations and the SMP itself is explicit in such a way that physicals attendance of the parties are required, and physical signings is required to conclude the SPA. But in terms of future developments of amending the SMPs and the Act itself, we have taken that into considerations to ensure that flexibilities are available just in case both parties agreed in such an arrangement, either by the developers or the purchasers. Right?
Maybe Dato Jeffry, I think over to you. Maybank views on e-signing, especially on the loan documents.
Yeah. For me, I think for Maybank, I think we are receptive to the use of e-signatures. In fact, we would appreciate that, right? Digital signatures, as long as it's within the scope of the Electronic Commerce Act 2006 and the Digital Signature Act 1997. I thought this is something, a new normal that I think we all should embrace too, right? Instead of physically, because of the mobility loss, the restriction that our customers can't go to the bank to secure document, they cannot go to the lawyer's office to secure document, and because of that, it held up a lot of documentation processes. So I thought we are receptive to it. The e-signatures, digital signatures, as long as it is like formally gazetted by the government, I thought that would be something that we would really receptive. Dato, I guess, I mean, that is, I did mention it a bit
for
earlier,
it,
no?
the banking sectors
so
will be for it.
Yeah, for it. Exactly.
Dato Kuek, you
as long
have
as it's gazetted, properly gazetted.
Yeah. Okay, Dato Kuek, you have anything to add on this?
It's just one of the side example of this New South Wales. I understand that New South Wales, they just passed this electronic transaction amendment, bracket, COVID-19, witnessing of document, close bracket, regulations. Yeah, these are the good examples that we should follow.
And Dato Soam?
Definitely, I think in the new normal, going forward, there are a lot of ways that we do our things has to be changed. And I think this is one of the ways. If we are not embracing it, then something is wrong. I think all stakeholders will totally agree that we need to be able to do things electronically and also to be witnessed electronically or virtually, rather than everything must be physically present. Otherwise, it's going to be very difficult. Example, like our meeting now, we are all having it, virtually. So it's something we don't do it this. So it's something that's a new normal now. So it's a start, and also because of this pandemic, it's actually pushing us, and then we all have to embrace the change.
Right.
Okay, I think the final question to all the members of the panel is actually that we all notice that if our COVID-19 Act at the moment now has not completely answered most of the issues, would it be time for us to actually move into amendments? And whether the government itself, especially KPKT, is actually in the midst of preparing some amendments to improve the efficacy of the COVID-19 Act. Tuan Simon, any moves in that direction?
Thank you, Dato. Amendments of Act 829, the COVID Act, is basically covered by bahagian hal ehwal undang-undang JPM and AGCs. We are just a party to it, but I think they also take inputs and feedbacks from the industries and the stakeholders in what best to actually look into in terms of revising the provisions and to actually provide additional provisions to strengthen the act itself lah. I think you can actually provide your inputs and feedback to bahagian hal undang-undang and AGCs for that matter.
Okay, Dato Soam, what is your wish list if amendments are what you call forthcoming?
I think we need to really sit down with all the stakeholders. That means the financiers, buyers, government agencies, because you must understand that we as developer, we have relationship with so many people, and of course, ultimately, most importantly, our contractors who are performing the construction work on site, delivering it to us, and also our purchaser. I think we really need to look at the interest of everyone here. And I think all of you agree this is a pandemic. It's not due to reasons we purposely want to take certain action. So we all must adopt this attitude of give and take if it's due to PCID. Of course, of people who purposely use because of other reason and use this as an excuse, I wouldn't cordon with that. Whether they are buyers, whether they are developers, whether they are contractors or whatever. We just want to move the economy and ensure that the livelihood of people are not affected. And as to what needs to be amended, there are quite a few. I think we will deliberate on this. And I think to all the developers out there, I want to echo this. Maybe Tuan Simon, please don't use the word EOT. There's no EOT given to you. It's actually a freezing of the time. That means you go to sleep on the 17th, you wake up already 1st of September. You didn't go through that period of time from the 18th of August to 31st of 18th of March to 31st of August. Okay, there is a freeze of time. There is no extension given to you as a developer. Please understand this. Please don't use a wrong word and then you get into a lot of trouble here. So that's my wish. I think I can see Tuan Simon there smiling away. So we are in concurrence on that, and I hope that please do cooperate and understand the whole act. Please go back and read this act. And I think we have another 10 more days or 2 more weeks running up to 31st of August. If any of the developers out there, buyers out there, bankers out there, agents out there who think there are certain portion of the acts that needs to be amended, the act needs to be extended, please do write into the relevant minister concerned. If it's the whole act, then it's the Minister of Law. Is certain particular section of the Housing Act under Part 11, then the Minister of Housing to amend. So please do write in as an individual, as an NGO, or as whatever, so that we make known to the people in authority that something needs to be done so that our livelihood will not be that badly impacted in the coming months, because the vaccine is still not there. The vaccine is still not there. So until the vaccine is there, all of us get vaccinated, then we can say, oh, this act can go to sleep. We don't need this act anymore. Otherwise, I believe, even though it's not a permanent measure, that's why they call it temporary measure for reducing the impact only. So it's not reducing 100%, reducing some of the impact. That's the title of the act. So with that, thank you to all of you for participating in this webinar.
Sure. Okay. Dato Kuek, you have anything to add on the amendments?
I don't have any, frankly, I don't have any wish list. Whatever wishes given by REHDA, I will support. Whatever wishes given by purchaser or banker, I will support. But my only wish now is to satisfy the question being asked. I saw a number of questions addressed to Dato Kuek. I don't have an opportunity to answer. My only wish is to fulfill that wish. If I can, pass the furnished question to me and let me answer and pass back to REHDA. REHDA can, Secretariat can secure to the relevant person.
Okay.
Thank you very
Actually,
much
for the information
okay.
of all.
And
all
I think that Dato' Charlie,
Yeah.
before you finish, I just want to show this copy of document that was given by after discussion with the Ministry of Housing. This was issued and published on our web page on the clarification on penjelasan pemakaian tema cadangan melibatkan Akta 118, Akta Pemajuan Perumahan, Kawalan dan Pelesengan. So all the examples, all the scenarios are actually indicated there. For those who don't understand, please go in there and have a look at it. And if you have a question, do post it to us. And if we can't answer you, we will post it to Tuan Simon.
Okay. Okay, I think we have come to the what you call end of our time, and especially many of the pertinent issues have been raised, and I think each and every member of the panel has actually answered to their best and cleared some of the situations. We hope that if you have any questions, then you can refer back to REHDA again. Then we will then seek further views, and especially those questions which are not answered in the Q&A. We will get the panel of speakers to actually answer them in written form. All right. So with that, I would like to take this opportunity on behalf of REHDA to thank everyone, especially Mr. Simon David, for joining us in his hectic schedule, Datuk Kuek, and also Dato Jeffry. Thank you so much for joining.
Thank you,
REHDA.
Dr. Saleh. Thank you, REHDA.
Thank you.
Thank you.
And
Thank you, Dr.
thank you to all the participants.
Thank you.
Bye.
Thank you. Bye.
Bye.